The coin market cap is used to recap everything that is said in this video. Also, Don and #039, forget to like and subscribe to my channel for more XRP news and news about other cryptocurrencies in general. Look at this now. If the SEC files an appeal against Ripple on January 15, what should we expect? In the United States, the Securities and Exchange Commission, SEC, wants to send its first brief in response to the Ripple case by January 15, 2025. The appeal has been made because the court already said that XRP is not a protection in and of itself. There are some parts of the ruling that the Securities and Exchange Commission, SEC, is appealing. One of these is how it decided to classify XRP sales made by Ripple on cryptocurrency exchanges and personal XRP sales made by Brad Garlinghouse and Chris Larsson, two executives at Ripple. It seems likely that those points of view will be important in the next brief. The Securities and Exchange Commission, SEC, which is led by Chairman Gary Gensler, will likely pay close attention to the court in #039's ruling on July 13 in the case about Ripple and #039's programmatic XRP sales. The agency continues to say that these kinds of deals should be seen as unregistered offers of stocks that are not registered because they are against the Stocks Act of 1933. Mark Fagel, who used to work as a lawyer for the Securities and Exchange Commission, spoke out about it on January 8. He said the court agreed with the SEC that Ripple had raised more than $700 million in a way that was and #039 registered with the SEC. But he also said that the appeal might not be able to go forward because of the change in government. It and #039's likely that the Securities and Exchange Commission will ask for a bigger fine than the $125 million that Judge Torres already ordered. Based on what the agency says, the present punishment does not go far enough to stop more violations. When the SEC files its appeal, it will go over the points it made earlier about how well the fine worked again. Stephen Alderode, who is the chief legal officer of Ripple, said that these efforts failed and were a waste of government-loaned money. In response to Judge Torres and #039 order, Ripple has changed how it does business, even though experts have said that a settlement may be coming soon. Ripple has just made changes to its XRP on-demand liquidity ODL transactions to meet the needs of the order. Jeremy Hogan and Mark Fagel, lawyers, say that some people think the case will be over by April or May 2025. They think that a settlement may be on the way. For now, though, things look better for Ripple in the United States. Garlinghouse says that 75% of the company and #039's open jobs are now in the United States. The company has also recently signed more deals in the United States. The people in charge of Ripple think that this will be good for the business while the lawsuit goes on. John Deaton, of CryptoLaw, recently made a live video in which he asked that the Securities and Exchange Commission, SEC, release the long-awaited report on William Hinman and #039's controversial speech in 2018. Hinman used to work for the SEC. Because of the speech, which made it possible for Ethereum to get through regulatory scrutiny, there are now big concerns about the chance of conflicts of interest in the SEC. What is the problem in particular? Empower Oversight, an independent watchdog group, asked the Office of the Inspector General to look into any possible conflicts of interest that might have been linked to Hinman and #039's speech. The report was given to the chairman of the Securities and Exchange Commission, SEC, a person named Gary Gensler, after the investigation was over. But for now, it has and #039 been made public. What Deaton said to the SEC. Because of the delay, Deaton, who is representing 75,000 XRP holders in the Ripple case, called the office of the SEC chairman directly. Within 10 days, he asked Gensler to make the results public in a way that was both polite and strong. It was also brought up that the results are very important for everyone, but especially for people who have been watching the Ripple case. It was clear what Deaton was trying to say. I and #039, do you like to ask that you please make the report available to everyone as a sign of respect? For the 75,000 people who own XRP, this is about to happen. As part of his work to support openness, Deaton asked others to do the same. He told everyone that to ask for the report to be made public, they should call or email the SEC. The goal is to make it very clear that the public has the right to know what in #039's in the report. This coming January 20th, Gensler will step down as head of the Securities and Exchange Commission. That same day, Donald Trump will be sworn in as president. Paul Atkins will be the new head of the Securities and Exchange Commission. As the deadline approaches, people in the Bitcoin community are working together to try to get the Securities and Exchange Commission, SEC, to release the Hinman report. They want to make sure that the government is held responsible for what it does. The Securities and Exchange Commission, SEC, has until January 15 to send an appeal brief in its case against Ripple. People in the cryptocurrency industry are keeping a close eye on the situation. Recently, something new happened at a time when lawyers like Bitcoin lawyer John E. Deaton are giving new information about how the case might end. In the last order, Judge Torres said that the Howey test did not apply to XRP trades on the secondary market, so they were not securities. This decision is the most important part of the current legal dispute. In light of this decision, Ripple was given some success. Even so, it was still possible to disagree about important governmental issues. The research that Deaton did shows that the SEC and #039's appeal position has a number of problems. He also says that Judge Torres didn't and #039 make a broad decision that would affect all sales of cryptocurrencies. Instead, he made a specific decision about Ripple and #039's case. The Securities and Exchange Commission might find it hard to make a strong case because of this narrow focus. The timing of the case can sometimes happen at the same time as possible leadership changes at the SEC. Due to the upcoming confirmation of Paul Atkins as head of the SEC, it is possible that the SEC will change how it regulates and enforces laws about cryptocurrencies. The legal actions that are still going on are more tough because of this time of change. People who follow the market have noticed that the price of XRP is still affected by what and #039's happening in the case. Before that, the price of the cryptocurrency had hit $3 during its 2021 bull run. If the case ends in a positive way, some analysts think that prices could go up. Some analysts think that the costs could hit $19. When Judge Torres announced his first decision, different lawyers had different things to say about it. Judge Rakoff has given different points of view in the same area, bringing attention to the complicated aspect of applying traditional securities laws to digital assets. The SEC will face a number of strategy problems if it goes ahead with its appeal. There is a chance that the Supreme Court will make choices about how to regulate cryptocurrencies that will set a precedent. This could make it harder for the SEC to enforce laws in the future. This risk may make it harder for the government to go after the appeal.